Hello and welcome to this Personnel Today webinar brought to you in association with Expert HR. Today we're looking at disability discrimination, one of the most difficult but important areas of employment law. What constitutes a disability? To what lengths should an employer go to cater for an employee's disability? And when can an employer justify discrimination arising from a disability? These questions and many more will be answered and discussed over the coming hour. I'm Rob Moss, editor of Personnel Today, and to help us answer these questions and more, we are joined today by Laurie Anstis from the law firm Boyes Turner. Before we start, I need to first go through a little housekeeping. These Personnel Today webinars are now some of the biggest events in the HR calendar, and we are currently joined by some 1,000 or so HR professionals from across the UK. As you would expect with an audience that size, you are able to listen to Laurie and me, but we're not able to hear you. Nevertheless, we do want to receive your questions and feedback as we go along, so we urge you to do this using the question panes on the left-hand side of your screen. I'll keep an eye on the questions coming in, but unless we feel that there's anything particularly pressing, we'll save up the questions for the end of the presentation in about 30 minutes' time. As well as all the people who are listening to this event live, people will soon be able to listen to it on demand, and we make that recording available in the next few days along with the PowerPoint slides and an audio transcription. Okay, let me introduce our speaker for today. Laurie Anstis is a senior associate with Boyes Turner, specialising in employment law. He acts as an advocate in employment tribunals across the UK and in the Industrial Tribunal in Northern Ireland. He is also an employment law trainer and member of the Law Society's Employment Law Committee. Laurie is also a contributing author to experthr.co.uk. Now, before I hand over to Laurie, I thought it would be a good idea to kick things off with a poll to see roughly the proportion of disabled employees in your organisations. So you will see the poll on your screens now. What percentage of your workforce has a disability? You can start voting using the radio buttons. Don't worry if you don't know. Many of you won't, but if you do have an idea, then try and give an indication using the buttons on the left. Okay, we're getting quite a lot of response in, and I'll just go over the results. You can carry on voting, but we're looking at, most people don't know, but about 60% or so of people do, and well, you can see it for yourself there. Most people think it's less than 1%, but some people, the next largest segment is 5% or more. And with that, I'll hand over to Laurie. Welcome, Laurie. Over to you.
Well, thank you very much, Robin. It's great to have so many people with us today for this topic. When I get the opportunity on one of these webinars, I always like to try and see if we can aim for a topic that comes up a lot when clients are calling me, and an area that I think really needs just a little bit of taking apart and putting back together in order that people can better understand it. So I'm very pleased that today I've got the opportunity to talk about disability discrimination law, which I've always thought has been one of the most complicated areas of law, but also one of the most important for HR managers, HR directors on a day-to-day basis. And in this webinar, we're going to concentrate on the three things that I see coming up most often in disability discrimination cases. That is, first of all, understanding when somebody is disabled, understanding how the law applies then to that person, and looking at the issues of reasonable adjustments and justifying discrimination arising from a disability, which are in practice the two areas of disability discrimination that come up most often. And in doing that, I'm going to be looking at what is and what isn't a disability, also drawing on some of my experience running cases in the employment tribunal to just give you some idea of how employment tribunals approach the question of whether somebody is disabled or not, We'll look at reasonable adjustments, and again, we'll look at the sort of things that employment tribunals are looking for when they're considering whether you've made reasonable adjustments or not. We'll look at justifying disability discrimination and the kind of steps you need to take and records you need to keep in order to be able to satisfy a tribunal that you've done everything you can. Then we'll be looking at some of the other kinds of disability discrimination. And before we get on to questions, I'll just look at a couple of future developments, some topical issues that are coming up at the moment in disability discrimination law. So first and most fundamentally, what is a disability? And I've set out for you there the statutory definition, which I'm sure many of you will be familiar with. And as with any legal concept, what lawyers like to do is to take a sentence like that, where we've got a physical or mental impairment, which has a substantial and long-term adverse effect on the person's ability to carry out normal day-to-day activities. And we will try and break that down and see what each of the individual elements of that mean. Well, first, of course, we're looking at the question of whether there is a physical or mental impairment. And it used to be under the old Disability Discrimination Act that, at least in terms of mental illnesses, you needed the illness to be a clinically well-recognized illness. And that meant that it needed to be something that doctors would find in their various diagnostic manuals. But these days, under the Equality Act, there's no need at all for the illness to be medically recognized. And I'm sure many of us will have come across cases where the illness seems to be, unfortunately, a complete mystery to the doctor, or where you have very sort of odd and different illnesses that people haven't really come across very often before, or you have collections of symptoms that the doctors really struggle to put a name to. Well, all of those can amount to physical or mental impairments. There's no need for a doctor to be able to produce a rubber stamp and say, I officially hereby diagnose this illness as such and such, or I recognize that this person has this particular very well-defined medical condition. As well as there being a physical or mental impairment, this needs to have a substantial effect. And substantial is a funny word because it seems to mean different things in different contexts. If I told you that I had won a substantial amount on the lottery, then you might be thinking maybe I've won thousands of pounds. Maybe some of you are thinking I've won hundreds of pounds. But actually, what substantial means in this context is simply more than minor or trivial. So actually, if I apply that to me saying that I've won a substantial amount on the lottery, actually, really what I'm telling you is I've won an amount that's more than minor or trivial. Now, I don't know what you consider a minor or trivial amount of money, but perhaps we'd be talking about 20p, 50p, maybe a few pounds. But that's a long way from the sort of thousands of pounds or hundreds of pounds that might have been in your mind before. And this is something that we really have to bear in mind when we're looking at the definition of disability. Substantial simply has to be more than minor. So that doesn't mean that it has to have a very big effect on a person's life. It simply means that it has to have more than a trivial effect on a person's life. It has to have a long-term effect. Now, that means that things that sort of pass, like flu or colds, stomach upsets, those kinds of things, won't count as being disabilities, even if they have substantial effects on an individual's day-to-day activities. To be a long-term effect, it has to last for more than 12 months, or be expected to last for more than 12 months, or for the rest of the individual's life, if, of course, their life expectancy is less than 12 months. There's also special provision made for recurring conditions where it may be that the effect comes and goes, and if the effect is likely to reoccur over a period of 12 months or more, then that will count as being a long-term effect. Now, you can see from those three things that except perhaps for the long-term effect, it's actually perhaps quite easy for people with particular medical conditions to fall in to the category of being disabled people, because all we need is some sort of physical or mental impairment that has a more than minor effect on you and has that effect over a long period of time, that is 12 months or more. And I'm sure we can imagine there's lots and lots of conditions that potentially would fall into those categories. Now, I've talked about it having to have a substantial effect. It has to have a substantial effect on somebody's normal day-to-day activities. And the Equality and Human Rights Commission have produced guidance which says that normal day-to-day activities are things that people do on a regular or daily basis. And they give examples like shopping, reading and writing, having a conversation, using the phone, watching TV, getting washed and dressed, preparing and eating food, carrying out other household tasks, walking, travelling, and taking part in social activities. Now, one of the things that you'll see about that is that it doesn't actually cover anything that amounts to a special requirement of the job. So when we're considering whether somebody's condition has a substantial adverse effect on them, what we're looking at is normal day-to-day activities in terms of work around the house, not things that are particularly specialised requirements of their job. So, for instance, if you were employed as a concert pianist, for instance, and you developed a condition in your hands that meant that you could no longer play the piano to a concert standard, that wouldn't of itself count as a disability, because what a tribunal will be more interested in is whether you can still pour a kettle, say, to make a cup of tea. Well, how is this decided upon in the employment tribunal if the tribunal come to have to decide whether somebody is disabled or not? Well, almost always the way in which this is dealt with is that the individual employee discloses their medical notes, typically their GP notes, plus the consultant's letters that might go with that. And the employment tribunal also expects to have some sort of written witness statement from the employee about the effect that the medical condition has on their day-to-day activities. Now, quite often I act for employers in these sorts of claims, and we discuss whether we accept whether or not a particular individual has a disability. And often the employer will say, well, surely we should say no, they don't have a disability, because if we don't accept that they have a disability, then we don't even really get into having to justify things. The difficulty with that is that if it looks from their medical notes like they have some sort of condition that does have an effect, and their statement that they come up with says that it does have an effect on them and that it's difficult, for instance, to make that cup of tea or to go shopping, it's actually really quite hard for employers to challenge that. Really what you're expecting your lawyer to do is to go into tribunal and try and harshly cross-examine this poor unfortunate person who's bringing the claim, and to say that actually their medical condition isn't as bad as they say it is. And unless you've got the private detectives who've been able to video record the individual sort of off dancing at the weekend or something like that, it's really very difficult to try and challenge what somebody says about their illness. And in fact, I've got a quote on the slide from the regional employment judge in the London North and West employment tribunals, basically pointing out that she does not think it's a very good idea for employers to dispute disability, because, as we've seen, the legal test for what counts as a disability is really very low. There will be some cases where you feel you have to dispute that, but I think we can see that most of the time the nature of that definition is really in the employee's favour, and typically it's not particularly difficult to show that somebody qualifies as being a disabled person. So some special cases of disability and some special things to consider. First of all, in deciding whether somebody is disabled, you have to disregard medical treatment or medical aids or appliances that they use. I had a case not too long ago that involved hip replacements, and the question was what the individual's state of health would be without those hip replacements. Quite often comes up in issues relating to mental health conditions which may be controlled by medication. Actually, what you've got to do is to assess how disabled they would be if they weren't taking that medication. There are particular medical conditions which automatically count as disabilities regardless of the effect they have on the employee. Any kind of cancer, HIV, and multiple sclerosis are automatically disabilities, as is severe disfigurement. And finally, although it's usually the case that it is the supposed victim of the employer's bad behaviour who is disabled, it doesn't actually have to be the victim who's disabled for them to get protection under the law. And we've certainly had cases where people have brought claims based on treatment by their employer when they say that they aren't disabled, but that the treatment has been in relation to a child of theirs who does have a disability. Well, what does this all add up to? Well, as we've seen with the concert pianist example, someone who can't do his or her job isn't necessarily a disabled person, but probably more people than you would think who have long-term health conditions are disabled. It's always best in these circumstances to give somebody the benefit of the doubt. Don't get too worried about whether or not somebody has a proper official diagnosis of their illness, because it probably doesn't matter very much. And finally, don't pretend you are a doctor. I do sometimes get these cases where people say to me, well, the individual can't possibly be suffering from XYZ illness because my aunt had that, and when she had it, it was a totally different thing or had totally different symptoms. I'm afraid if you take that kind of line, then the very first question the tribunal is going to ask you is what your medical qualifications are that enable you to say that this isn't really the condition that the person says that it is. So, moving on then to look at the types of disability discrimination that can arise. First, and I think often in practice most significant, is the question of reasonable adjustments, a phrase that I'm sure a lot of people are familiar with. So, when do you have to make reasonable adjustments for a disabled employee or a disabled job applicant? Well, you have to make reasonable adjustments where you have what the law calls a provision, criterion, or practice, which essentially means anything that you do, or maybe even something that you don't do, which puts the disabled person at a substantial disadvantage compared to people who aren't disabled. And again, in this context, substantial means more than minor or trivial. So it might not be a particularly big disadvantage, it just has to be one that is more than minor or trivial. And this provision, criterion, or practice doesn't have to be any sort of written rule or even anything that you've necessarily formally thought about or imposed on the individual. Many work customs or sort of unwritten rules can count as being provisions, criterion, or practice. So examples of this would certainly include things like working hours, the equipment that you provide, if you expect everybody to use a particular kind of computer equipment, at a particular desk, sitting at a particular chair, even if you expect people to do their work from the office rather than from their home or some other location. Really, the things that can count as provision, criterion, or practice are extremely wide, and almost anything that you do in the course of your work can count as being a provision, criterion, or practice. And it's not difficult to see that some of those things could put disabled people at a disadvantage. So a classic example would be the expectation that people will use a standard computer screen. That might put somebody at a disadvantage if they have a visual impairment and need a larger computer screen or something of that nature. There are also some special rules about alterations to premises and equipment, which I won't go into in detail because I don't tend to see them come up very often in practice. So what do you have to do if you have this particular obligation to make reasonable adjustments? Well, you have to make reasonable adjustments in order to remove the disadvantage that the disabled person is subject to. And of course the question that people always ask me after that is, well, how far do I have to go? How far do I have to go in making these adjustments? I've got somebody, for instance, who can no longer drive. Do I have to employ a separate person who does the driving for them? Excuse me. And what I always say to people in those circumstances is that the main thing that you have to look at when you're thinking of reasonable adjustments is you really just have to sit down with a blank sheet of paper, and you have to write down on that blank sheet of paper the things that you have considered doing, and against each of them, whether you can and cannot do them, and if you think that you cannot do them, why you cannot do them. And I've gone on to say why, because I think why is always the key point here. And I recommend to all my clients that they think of themselves as having a sort of nagging 4 or 5-year-old child sitting beside them as they're writing out their list. If you say that something can't be done, that nagging child is going to ask you why. And if you then say to that child, well, because it's too expensive, then that child's going to say to you, why? And then going to say to you, why? Why is it too expensive? And that may just prompt you to think again and think, well, actually, how much is this going to cost? How much is this going to cost as against other things that we do for people, as against the salary, for instance, of this particular employee? And if you can survive this 4 or 5-year-old child test of the person who always asks why, then you are in a very good position to defend your decision when it comes to an employment tribunal. Now, some point that people often make to me in those kind of situations is, well, if we allow this disabled individual to start work an hour late because of something to do with their disability, isn't everybody going to want that? Isn't that favouring the disabled person, and won't the people who don't have a disability complain and point the finger and say that they want that privilege as well? Well, the answer to that is there is nothing in law that prevents you from favouring the disabled employee. In most cases of disability law, of course, we know that it works both ways. It's against the law to disadvantage a woman because she's a woman, but it's also against the law to disadvantage a man because he's a man. But it doesn't work two ways in the question of disability. It is against the law to do certain things to a disabled employee or to fail to make reasonable adjustments, but it's not against the law to privilege the disabled employee as against somebody who doesn't have a disability. And very often, in fact, making reasonable adjustments is going to require you to treat the disabled employee better than you would treat a non-disabled employee. So what about things that won't be reasonable adjustments? Well, there's a few principles that have come through from the case law about things that won't amount to reasonable adjustments. First of all, adjustments that won't work won't be reasonable adjustments. If there are things that are being suggested by the employee that simply won't work, that simply won't improve the situation, then they don't have to be made. Also, if you've got an employee who is off sick, then it's important to understand that the main significance of reasonable adjustments is getting them back to work. So things that won't help them return to work won't usually be reasonable adjustments. And you can include within that things like getting them to make applications for ill health retirement. It's not something that's going to get them back to work, and it's not something that really falls within the remit of reasonable adjustments. There's also a case from a few years ago that suggested that matters that relate to personal care of the employee won't count as reasonable adjustments. In that particular case, it was somebody working for the police, and the only adjustment that they needed to be able to carry out their work was to have somebody who would assist them when they went to the toilet. And the court, or the tribunal in that case, said, no, that's not a reasonable adjustment because it's about your personal care. and it's not about something to do with the job. I have to say that case might not be decided quite the same way today, but it's certainly a case that comes up quite a lot of the time when you're looking at questions of personal care. So before we go on to our next slide, we've got a poll, and this is in respect of job applicants, because of course your obligation to make reasonable adjustments can apply so far as job applicants are concerned. So the question is, when does your organisation ask job applicants about adjustments they might require? And there is then a range of answers from it's not asked at all through to being asked in application forms and application packs, etc.
Okay, thanks, Laurie. I think for this one, forgive me if I'm wrong, but I think you can vote for more than one at once. So if you do more than if you do ask job applicants about adjustments, then you can tick more than one option there. So I will leave it open a little bit longer just while you fill that in. I won't skip to the results quite yet. We've had most people vote now, so do just tick the boxes that are relevant to your organisation, and then we'll have a look at the results. Okay, we've got 1,000 people voted now, so let's have a look and see. Okay, so I mean I won't go through and read them all out, but it looks like the two most popular options are after the employment offer has been made and on the application forms. Very few do it on any advertising. Okay, back to you, Laurie.
Yes, thanks, Rob. Interesting results there. I think both the people who ask about it on application forms and after the offer of employment are probably along the right lines, and I see we've got some people who ask in application packs, which I think, again, there's good ways of doing that. You do, of course, have to make reasonable adjustments for job applicants during your selection processes. So it's good practice to ask in any application forms about adjustments that people want to the application process, although strictly speaking that ought to be confined to the application process itself rather than the carrying out of the eventual job. And questions relating to carrying out of the eventual job, I think the people were referring to after the offer of employment has been made. So let's just have a look at some of my tips on making reasonable adjustments. As I've suggested, make notes of your thinking, so have this blank sheet of paper where you write down what you've thought about and why you've rejected it if you have rejected it. I think you should then share those thoughts with the employee so that they understand your thinking and so that they get the opportunity to comment on what you're thinking. With some adjustments you might need expert advice. That's particularly the case where there are adaptations to technology or something like that required. There's really an enormous range of adaptations and special aids available these days, and very often you are going to need advice from specialist suppliers on that. If you decide you're not going to make an adjustment that an employee has asked for, then I think you should tell the employee and set it out in writing why you're not going to do that adjustment. Apart from anything else, I think that will help you to be clear in your thinking if you have to explain it to the employee. The next kind of disability discrimination that we come across all the time is discrimination arising from a disability. And this is discrimination not because of the disability, but because of some consequence of the disability. And frankly, this happens all the time. Those of you who have people off on long-term sickness absence at the moment, if you are not paying them in full, then you are engaging in discrimination arising from a disability, because there's every chance that they are disabled, and it's their disability that's the reason why they're off work, and it's them being off work that means that you're not paying them. So we can run a sort of a chain of causes through from their disability to the fact that they're not being paid. Similarly, those of you who have ever dismissed an employee who has been off on long-term sickness absence, again, you've been engaging in discrimination arising from a disability because it's highly likely that it was a disability that meant that that employee was away from work, and it was the employee being away from work that meant that you ended up dismissing them. As I say, this happens all the time, and it is perfectly okay provided you can justify what you have done. And that means in legal terms that you need to have a legitimate aim. So if you are looking at something where you are saying, again, the classic example is somebody who is off on long-term sickness leave. If you are thinking, we really need to get on, we've had all our medical reports, we need to dismiss the person, you've got to think, why are we doing this? And set out what it is that is ultimately your aim in this. And then the secondary question is what you are doing a proportionate means of meeting that aim? So is there any other way that you could carry out that particular aim that you have? I mean, again, the classic case is the failure to pay sick pay to somebody who is off on long-term absence. Well, you have an aim there, legitimate aim, which is that as a general rule you want to pay people who come to work. You need to run your business efficiently and you need to make the most of your money. So typically you would not extend beyond your contractual sick pay or SSP any payments of sick pay to people who aren't at work. Generally speaking, that is accepted as being a legitimate aim, and it's considered a proportionate means of meeting that legitimate aim to no longer pay somebody sick pay once they've been off for a particular period of time. You do, though, have to be careful of reasonable adjustments, because if there was a reasonable adjustment that you could make that would mean that the person could return to work, then maybe you aren't so justified in refusing to pay them sick pay. There are, of course, other types of disability discrimination, and I do need just briefly to refer to them. First of all, harassment. As we know, harassment in these cases is judged in the eye of the victim. Very often, of course, harassment is sought to be excused as being banter, which employment tribunals are, I think, suspicious of, and it's not often an excuse that is accepted by them. Do bear in mind what I said earlier, that it doesn't necessarily have to be the disabled person themselves who are the victim. And if there is teasing carried out, for instance, because the individual concerned has a disabled partner, then that can be disability harassment as much as if the person themselves is disabled. Then there is victimisation, which I tend to think is better described as being retaliation. That is when you get back at somebody who has raised complaints of disability discrimination by doing something bad to them, refusing them a pay rise, refusing to listen to their grievance, something like that. That is against the law. We also have concepts of direct and indirect discrimination, although I'm not going to deal with them in this webinar because I think in practice it's very unusual to come across those. Just finally, before I hand back to Rob and we look at a poll and your questions, a couple of things that I think we're going to hear more of in the field of disability discrimination over the next few months and years. The first is the question of whether obesity can count as a disability. Some of you may remember there was a bit of a stir in the summer about a European court case in which the Advocate General, who's a sort of official lawyer who advises the court, had a look at the question of whether obesity can amount to a disability. The Advocate General in that case said effectively that obesity can be a medical condition and it can have an effect on your normal day-to-day activities. I don't think that surprised any lawyers or anybody who'd been following this particular strain of law, because in fact the UK courts had said much the same. So really the point being that obesity can have medical consequences and consequences for a person's day-to-day activities, and to the extent that it falls within the usual definition of disability, it will certainly count as a disability. The second point is a more broader philosophical question of whether we're looking at a medical model of disability or what's called a social model. In the UK at the moment, we've adopted the medical model of disability, which really looks at disability as being a matter for the doctors, I suppose. It's a medical condition, and we look then at what people can and can't do. But in some international conventions, disability is looked at more on the basis of a social model. And for instance, the UN Convention on the Rights of Persons with a Disability talks about those who have long-term physical, mental, intellectual or sensory impairments, which in interaction with various barriers hinder their full and effective participation in society on an equal basis with others. So it's looking at very much a broader picture and almost looking at society's reaction to the person rather than questions of whether the person carries with them a particular medical diagnosis or not. And we might see within that, as time goes by, a gradual expansion of some of the categories of people who are considered to have a disability. But I can see that as we've gone along, there's a lot of questions that have come through. So I'll hand over back to Rob now for our final poll, and then we'll get on to the questions.
Thank you, Laurie. Very interesting stuff. And clearly, it's far from straightforward. I think we're going to kick off with our final poll of today, which is going to look at policies. We've got loads of questions coming in. Do keep them coming. We've had over 100, but you still might be a lucky one and get your question in front of me at the right time. So do keep asking questions, and we will endeavour to answer these questions post-webinar as well, and publish them, some of the answers on Personnel Today and Expert HR. Okay, so our final poll is about the HR policy that you have in place in your organisation. So does your organisation have a formal policy that deals with disability issues? And then you've got 3 choices of yes and 1 choice of no. So the 3 choices of yes are essentially yes, it's covered in the main employment policy. Yes, it's covered in the standalone disability policy. Yes, it's within a diversity policy. And finally, no, you don't have one. Sorry, there's no don't know on this one, so if you don't know, then just don't vote. Okay, so thank you. Everyone's voting. We've had 800 responses so far, so let's have a look at the results, which will be fairly representative. Okay, so most people cover this off within a diversity policy, more than half. And around 13 or 14% don't have one at all. Laurie, have you got any comments on that? What would you suggest is the best way to handle this matter?
I think it depends a bit on the size of the employer, actually, Rob. I think it's very ambitious for a smaller employer to have a standalone disability policy. And for smaller employers, certainly within the diversity policy or as a main employment policy is perfectly acceptable. I suppose typically with discrimination and diversity issues, I do like to see there being a diversity policy rather than relying on something else in the employment contract. As for the standalone disability policy, I can certainly imagine larger employers and employers in particular industries, maybe where physical fitness is essential, would benefit from having a standalone disability policy. The example that springs to mind, for instance, is the police service. There's quite a number of disability discrimination claims that involve the police service because of the particular issues that there are there and issues around physical and indeed mental health requirements for the police service. So in those kind of organisations, I would say a standalone disability policy is well worthwhile. Okay.
Thank you. Right, we now turn to our audience, and our first question is from Claire, and she asks, what if the employer doesn't know that someone is disabled?
Right, yeah. The law does not require you to make reasonable adjustments if you didn't know and couldn't know that the individual is disabled. So if there was nothing to suggest to you that the individual has a disability, then you're not expected to carry out reasonable adjustments. However, if there are suggestions that might hint at there being a disability, for instance, frequent medical certificates, things like that, then you can't close your eyes to the possibility that there is a disability. So general idea is you don't have to make reasonable adjustments unless you knew or should have known from what you were being told that the individual had a medical condition which might add up to being a disability.
Okay, thank you. Next question is from Ian. Thank you, Ian. Under the Equality Act, are we bound to redeploy a disabled employee in an alternative role as a reasonable adjustment where they are unable to continue in their existing role, i.e. meaning that they do not have to interview for that role?
Redeployment can amount to a reasonable adjustment, and there was a very famous case a few years ago that said that that would often mean that the disabled person would bypass the usual recruitment processes and simply get appointed to the job. So the disabled person would have priority in any redeployment. So as a general rule, yes, if you had a job you could redeploy them to, you should do that, and the disabled person should get priority for that job.
Okay, thank you. This one is from Katie. Laurie, are disciplinary processes triggered when employees accrue a certain number of absences? Can you provide some guidance about recording disability-related sickness absence?
Right, yes. Again, there's quite a few cases around this whole point of what you do with automatic sickness absence triggers. Part of the problem is that it's only often after the event that you know whether or not somebody's absence is to do with a disability or not. So I would say that at least the first thing that you do is you simply tot up the sickness absences and you follow your normal procedures. Now I would imagine that at some point that means that after 10 days absence or whatever it is, you invite the individual in for a meeting. You've talked of disciplinary. I sometimes don't really like using the language of disciplinary procedures in terms of capability and illness cases, but either way, you're going to be having a meeting with the individual. Now, one of the things that can be considered with the individual in that meeting is what actually is the medical problem that's keeping them away from work. That may then lead you on a sort of train of inquiry, which leads you to realize that the individual does actually suffer from a disability, in which case you have to make reasonable adjustments in what then follows in your sickness absence procedures. But in terms of triggering the first meeting, I don't think that you ought to distinguish between disability-related and non-disability-related absences, because frankly I think very often you'll have no way of knowing which is which, and often that first meeting is a very valuable opportunity to discuss with the employee their particular condition. I do tend to shy away from using the language of disciplinary procedures where it's a matter of capability or health there. Okay.
Thank you. Do keep your questions coming in, and we'll get through as many as we can. We've still got about 15 minutes to go. Okay. This one is from Jonathan. What factors would a tribunal take into account when determining whether or not a capability dismissal on the grounds of disability is fair?
Capability dismissal on grounds of disability, the main point is always going to be should the employer have waited longer for the individual to come back to recover and thereby come back to work. And of course in a disability case that would be come back to work with reasonable adjustments. So the usual question that the tribunal is answering when it's looking at that is to say this particular employer could not have been expected to wait any longer for this individual to come back. Now, in considering that sort of thing, the tribunal is always going to be interested in what medical evidence you've got, because the medical evidence might be that the individual isn't going to come back for another 12 months or maybe even ever, in which case it's frankly easy to justify a decision to dismiss. The medical advice may be this person can come back within a month if only you would allow them to use the parking space closest to the office. Well, that, of course, that's a whole different thing, and you can imagine a tribunal would take a very different view of that to where the medical evidence suggested that the individual would never be in any fit state to come back.
Okay, interesting one from Debbie relating to cancer. Would an employee who is in a period of remission be considered to have a disability?
It's highly likely that they would, Debbie, and I'll tell you why. I mean, of course, within remission, there's always this question of is it going to reoccur, and if there is a chance, or sorry, if it's likely to reoccur, then it will count as a disability. But there's another way in which things can count as disability, which is that actually people who have suffered disabilities in the past are protected. So the fact that this individual has suffered from cancer, even if it then later turns out to be the case that the cancer has entirely gone away, will still retain a residual protection as a disabled person because they have previously suffered from a disability.
Okay. Now, interesting one. So, relating to your answer earlier, Laurie, to the question from Ian about redeploying a disabled employee to an alternative role, Gerdit asks a related question about what to do if the disabled employee has refused. In this particular case, the employee has said that it's not a suitable alternative as the role is paid less than their existing role. But that is because the role involves less responsibility. That's from Gerdit. Thank you, Gerdit.
Okay. Well, if you've made the offer and the employee has refused, there's nothing much more you can do. You have to look around, of course, to see if there's any other reasonable adjustments, but you can't force the employee into work. If there are no other reasonable adjustments, then you reach the end of the line on the reasonable adjustments that you can make, and you need to decide then what you're going to do with the employee, and of course dismissal may come on the agenda. There are sometimes difficult issues around this whole area of redeploying people and cutting their pay so that their pay for the job matches the pay for the new job rather than the pay for the old job. I tend to think that's something that you can do, that they get paid for the new job rather than paid for the old job. But I get a lot of lawyers acting for employees who try to argue with me that actually it's the old rates of pay that should prevail. I don't think that's right, but it's not something I've seen come before the tribunals yet.
Okay, thank you. Okay, this one's from John. Can you briefly explain what the difference is between direct and indirect discrimination from a legal point of view around disability?
Yes, sure. Direct discrimination is where something bad happens to somebody because they are disabled. And in this context, what we mean is pretty much because they bear that label of being a disabled person. So it's as if the employer were to have a rule that says we simply do not employ people who have HIV. That would amount to direct discrimination. The reason why you don't come across it very often is far more often employers are concerned about the consequences of the disability rather than the fact of the disability itself. So in matters related, for instance, to physical fitness, it may very well be that the employer doesn't care at all about the precise nature of the disability, but that they're very concerned that a consequence of the disability is that the individual cannot physically carry out the duties of the job. Indirect disability discrimination is where you have got one rule that you apply to everybody, but which a disabled person would find more difficult to comply with than a non-disabled person. Disabled people would find more difficult to comply with than non-disabled people. Almost always I tend to find that that kind of problem will fall within discrimination arising from a disability, and it's rare that you actually have either indirect or direct discrimination argued. I don't think I've ever really seen it argued properly in tribunal. We're almost always on about reasonable adjustments or discrimination arising from a disability.
Okay, thank you. Back to disciplinary. This one's from David. Can we start a disciplinary process with regard to an employee who has a disability that occasionally makes him violent, where that has resulted in him lashing out at a colleague?
Yes, you can. And of course we often do have these things where the disability contributes to what might be called antisocial tendencies like violence. Now, if it is the case that the end result of that disciplinary process is that the individual gets dismissed, well, you've really been engaging in what I was talking about with discrimination arising from a disability, because what the person will say is, well, the only reason I have this tendency towards violence is because of my disability. We know, though, that that is okay, provided you can justify it. So there you've got to look at your legitimate aim and your proportionate means. And in cases of violence, it's not particularly hard to find your legitimate aim. You have a perfectly good legitimate aim in saying you want to ensure that you have a peaceful workplace. So the question is then, is dismissing the person a proportionate means of achieving this peaceful workplace? And there you've got to consider things like, was this just a total one-off? Did it arise in a particularly difficult situation, and there's ways of preventing that situation arising? Are there any precautions that you can take to handle that or to prevent it arising again? And if the answer to all of those things is no, then I think dismissal would very often follow. And in fact, where somebody is arguing that a tendency towards violence is a sort of a natural and consequence of their disability, and where it's something that simply cannot be dealt with through control mechanisms or medication, then I think in some senses that almost makes it easier to come to a decision to dismiss than where it's somebody who's saying, this was just a complete one-off, I don't know what happened, never happened in 20 years, and I'll give you my word it won't happen again.
Thank you. I suppose this one's related. We've had quite a few people bring up the topic of alcoholism and drug addiction, and it kind of relates to that last one. Can the effects of alcoholism be classed as a disability, and what happens when that leads to unwanted behaviour in the workplace?
I'm glad that point's come up, because I was involved in the case that went to the Employment Appeal Tribunal and decided that particular point. First of all, alcoholism and other addictions are specifically excluded from being disabilities, but of course they may well have consequences which do amount to disabilities. So, for instance, if you drink so much alcohol that there is damage to your liver, then that damage to your liver may result in a disability regardless of how the damage was sustained. Similarly, I think sometimes we see those connections between addictions and various mental health issues. Disability discrimination law doesn't sort of distinguish between good disabilities and bad disabilities, as it were. If your disability occurred because you jumped into the canal to rescue a drowning dog, then that is really looked on it the same way in the law as if your disability was occurred when you'd had a bit too much to drink and you suddenly thought it would be a good idea to jump off a very tall wall. Disability discrimination law doesn't sort of make moral judgments as to how the disability came about. They're all treated the same. But alcoholism and addictions of themselves do not count as being disability.
Okay, thank you. Sarah asks, she says, our sickness policy provides 2 months sick leave at full pay. Would it be a reasonable adjustment to pay a disabled employee who is off sick full pay for more than 2 months?
I think what you have to do with that is you have to go through the sort of concept of why you would be making that reasonable adjustment. I've mentioned before that the main point about reasonable adjustments for people who are off on sickness leave is to get them back to work. Paying extra sick pay for that individual might be a very nice thing to do, and it might be the sort of thing that a decent employer should do. But I don't see that you have to do it as a reasonable adjustment unless there's really some prospect that that is something that can help them to return to work. Sometimes, of course, people say, well, you know, pay me or I'll be suffering so much financial pressure that my illness isn't going to get any better. I tend to think that isn't a reasonable adjustment. But I mean, it may be that some judges would disagree with me on that. I don't know. But I think what you've got to look at is how would it help the individual to get back to work. And if you're going to do that, then you need to have some idea of how paying this extra sick pay is going to help them.
Okay, we're running out of time. There's an interesting one from Georgette, and it relates to pregnancy, Laurie. Do reasonable adjustments requirements apply to a pregnant employee?
I was just thinking of this when we were starting off the webinar, Rob. And I think, strictly speaking, they don't, because I'm not really sure that I suppose pregnancy is a kind of medical condition, but of course it's not a long-term medical condition. I mean, pregnancy, of course, can trigger all sorts of complications. Even with the Duchess of Cambridge, we've got the morning sickness issues. But again, generally, they are short-term. I don't think pregnancy of itself can be considered a disability. Pregnancy can trigger things that might amount to disabilities, but only if they have that long-term effect. Of course, treating somebody who is pregnant badly, well, generally speaking, I'd be looking at pregnancy and maternity discrimination law rather than disability discrimination law. Although, as I say, pregnancy can, with complications, lead on to things that will count as being disabilities. Okay.
Well, thank you. We are coming up to an hour now, so I think that is all we have time for. Yes, it is. Okay, so thank you, Laurie, for answering those questions. It was a really good Q&A session. Thank you to everybody who's submitted their questions. As you'll gather, we've only got through a minority of them. We will endeavour to go through and answer as many of those online on Expert HR over the coming days and weeks. Okay. Unfortunately, that is all we have time for. As you log out, please fill in our exit survey to give us some feedback. It's really appreciated. Our next webinar is a week today, and it's called Recruiting the Mobile Candidate, and it's brought to you in association with Indeed.com. I'll be joined by 3 experts in mobile recruitment, and we'll be looking at what employers should be doing now that more than half of job searches are done on a smartphone. Okay, you can sign up for that webinar and browse a whole archive of on-demand webinars at personneltoday.com/webinars. You will even find a webinar that Laurie and I presented last year on managing long-term sickness absence, which is kind of related to what we've been talking about today. Okay, that just leaves me to thank our guest speaker, Laurie Anstis from Boyce Turner. Thank you, Laurie. You've been listening to a Personnel Today webinar in association with Expert HR. Thanks for joining us, and goodbye.